matter of Butcher and the estate of Euan returning.
Yes, Lord.
May it please you, my lords. This is an appeal from a decision of Mr. Justice Kerr, delivered on the 26th of November last year. There are two grounds of appeal. The first is that the judge erred in law in holding that the jurisdiction to set aside a judgment procured by fraud extends to setting aside the judgment against a non-fraudulent party to the original proceedings. The judge gave permission to appeal in respect of this ground at the consequential hearing on 12th of December. The second ground of appeal is that the judge erred in holding that the defence of late cheese was not made out. By order of my Lord, Lord Justice Singh, dated 26th of March this year, you directed that the question whether permission to appeal in respect of this ground should be adjourned to this court on a rolled-up basis. I appear for the appellant, together with Mr. Banks-Jones. Mr. Bacon appears for the respondent. We suggested to Mr. Bacon that the time between us should be divided equally and any unused time in my opening be reserved for my reply. I think he is happy with that approach.
Very good.
The first ground of appeal raises an important point of principle. Does fraud unravel all against just the fraudster, or against the fraudster and innocent third parties? We submit that the answer to this is the former, and that conclusion is clear from a careful consideration of the rationale underlying, or the rationale justifying the setting aside of judgment. Now that might seem at first blush, it seems to be counterintuitive, as we all grew up with the observation that fraud unravels all ringing in our ears. However, we submit that once regard is had to the principles underpinning that proposition and more recent authorities, the correct answer becomes clear. So in our submission, the question is binary. It is either one or the other, with no room for a middle path, subject only, post the Privy Council decision in Lindsay, to the question whether the new action is abusive. However, as you will see, this is not the route the judge took. He held that the judge had an equitable jurisdiction to set aside judgments against innocent individuals. So what I think I need to do before taking you to the relevant authorities is to take you through the judge's reasoning so you can understand how he arrived at the conclusion that he did. Now, the judge adopted the right starting point by referring to the Court of Appeal decision in RBS and Highland Financial Partners and the judgment of Lord Justice Aikins. For convenience, you can find that at paragraph 92 of the bundle. That's the call bundle, tab 5, page 60. And he says there, where a party alleged for the judgment must be set aside, which is obtained by the fraud of another party, the principles to be applied are those stated by Lord Justice Aikins in Royal Bank of Scotland and Highland. And the principles are, briefly, first, there has to be a conscious and deliberate dishonesty in relation to the relevant evidence given or action taken, statement made or matter concealed, which is relevant to the judgment now sought to be impugned. Secondly, the relevant evidence, action, statement or concealment performed with conscious and deliberate dishonesty must be material. Material means that the fresh evidence that is adduced after the first judgment has been given is such that it demonstrates that the previous relevant evidence, action, statement or concealment was an operative cause of the court's decision to give judgment in the way it did. Put another way, it must be shown that the fresh evidence would have entirely changed the way in which the first court approached and came to its decision. Thus, the relevant conscious and deliberate dishonesty must be causative of the impugned judgment being obtained in the terms it was. Thirdly, the question of materiality of the fresh evidence is to be assessed by reference to its impact on the evidence supporting the original decision, not by reference to its impact on what decision might be made if the claim were to be retried on honest evidence. So far as Mr. Butcher was concerned, the pleaded case against him was that he was dishonest. However, all allegations of dishonesty were abandoned on the first morning of the trial. And notably, and more importantly, the judge expressly found that none of the conditions expounded by Lord Justice Aikins were made out. I want to take you to a couple of passages in the judgment before taking you to the judge's conclusions about this. The first is paragraph 12, which you find on page 45 of the judgment, still in tab 5 of the core bundle. And he says this in paragraph 12. In fairness to Mr. Butcher, it cannot be said that he gave dishonest evidence to His Honour Judge Bird or to me, nor that he knew he was acting improperly in respect of his appointments as an enforcer of debts owed to Outlook, nor that he knew Mr. Fradgley was anything worse than a tough businessman, rigorously enforcing debts owed to his company Outlook. This case would be more straightforward if it were pleaded and proved that Mr. Butcher and Mr. Fradgley acted in cahoots, but that is not suggested. Rather later in the day, the Lindsays have confirmed they do not in these proceedings allege any fraud against Mr. Butcher. And he makes a similar point in paragraph 61, which you find on page 53 of the bundle. Refers to the trial taking place in 2014. The judge's attention was very much focused on the conflict of evidence between the Lindsays and Mr. Fradgley. They and he gave evidence. So did Mr. Butcher for an hour or two, but his evidence was peripheral. He is barely mentioned in the reserved judgment, and in the draft version it was mistakenly recorded that the claim against him was stayed, as was the claim against BT. Now that leads to the conclusion of paragraphs 150 and 151 of the judgment, which can be found on page 70. On 150, the only judge says this: the requirements for setting aside the judgment as against Outlook are therefore met, and I'm willing to make an order to that effect. However, I must also consider the claim to set aside the judgment as against Mr. Butcher, which is another matter. The first point is that unlike Outlook, Mr. Butcher was not consciously and deliberately dishonest before His Honour Judge Bird in relation to relevant evidence, action taken, statement made or matter concealed. Lord Justice Aiken's first requirement in Royal Bank of Scotland is therefore not met in his case. Nor, to state the obvious, apologies, I pressed the wrong button. Nor, to state the obvious, are the second or third requirements relating to materiality met in his case. Indeed, the second and third requirements do not logically arise if the first requirement is not met. I can therefore only consider setting aside the mentioned judgment as against Mr. Butcher if the equitable jurisdiction to do so extends to setting aside a judgment tainted by fraud against a party who is not implicated or complicit in the fraud. He goes on to say that to answer that question, it's necessary to look carefully at the juridical nature of the cause of action.
Can I just ask you to unpack a little the paragraph 151
Yes.
statement, that either the second or third requirements are not met or they don't logically arise? What do you think the judge meant by that? I mean, the first requirement is that there was conscious and deliberate dishonesty.
Yes. I think he's thinking that if you don't say yes to that, conditions 2, Lord Justice Aiken's conditions 2 and 3 don't fall to be considered, because you need to have conscious dishonesty to get the ball rolling,
Yes.
as it were.
Well, there was conscious dishonesty, it's just not on the part of Mr. Butcher.
Exactly.
So he seems to be saying that the second and third requirements have built into them that they are, the materiality results from the conscious dishonesty of Mr. Butcher,
Yes.
which may not be right.
May not be right. But he answers, he having said that, he then goes on to consider Mr. Butcher on the basis that Mr. Butcher was an innocent co-defendant, but concludes that in any event there was this jurisdiction to set aside a judgment.
Speaking for myself, Mr. Wardle, one way of analysing the issue which arises in the present appeal may be that we do have to consider something which no previous authority has had to consider, which is if you have the three elements of Lord Justice Aiken's test, but they're satisfied by different people. What I mean by that is that, on one view, it could be said that the judgment obtained by Mr. Butcher is tainted by the fraud. There is an operative cause, so it could be said that the second element of the Lord Justice Aiken's test is met in this case. And what we have to consider is whether it then is fatal in law that it's not Mr. Butcher who was dishonest as per the first element.
Yes, I completely agree. I mean, is the conclusion that does it follow that because Mr. Fradgley satisfied all three tests, does it follow the whole judgment gets set aside,
or at least may be set aside,
or just against?
But your submission, as I understand it, is that it's incapable of being set aside.
Yes,
because the principle simply doesn't apply in this context. Is that right?
But absolutely, because as I'll be going on to submit in due course, the underlying rationale is that the victim of the fraud has a substantive cause of action against the fraudster to have the judgment set aside.
Yes.
And if you analyse it in that way, that doesn't apply to Mr. Butcher.
Yes. Thank you. Right. I think you were showing us.
I'm about to take you to 152.
Yes.
And he says, to answer the question, it's necessary to look carefully at the juridical nature of the cause of action. As regards the fraudulent party, there's no difficulty. We might, with Sir Geoffrey Voss, MR, regard it as akin to an action for deceit, as he put it in Tinker. I regard it as, in the words of the authors of Meagher et al. Opsit, a suit in equity.
I think it's pronounced Ma.
Is it? I
It
apologise.
is. No, there's no need for apologies, but I think it is.
Oh, okay, thank you. A suit in equity to impeach a judgment, a separate proceeding asserting a personal obligation to give up the fruits of unconscionable conduct, or as Lord Sumption put it in Tacker at 60, a special jurisdiction to reverse transactions to procured by fraud. Now, I've obviously come back to the extract from Montgomery and Lehane in due course, and will take you to Tinkler in due course, but I just note in passing that we will be submitting that he was wrong to disregard what the Master of Rolls had said, particularly as what the Master of Rolls said was consistent with the majority in Tacker. Now, of course, I'll come to Tacker later. But sticking with the judgment, the judge went on to conclude at paragraph 153 that the court can, in an appropriate case, exercise the equitable jurisdiction to set aside a judgment against an innocent party. And in reaching this conclusion, he drew comfort, as you'll see from the paragraph, from the fact that equity has an inherent flexibility and capacity to adapt to new situations. Then in paragraphs 154 to 155, he says that the setting of the side of a judgment isn't done to punish the fraudster, it's done to protect the legal process. And he finds that such a view accords with the proposition that fraud unravels all, and in particular with Lord Buckmaster's analogy, and in particular draws comfort from Lord Buckmaster's dictum, famous dictum in Jonesco and Bird. Then at paragraph 156, he says this: I'm not thereby saying that a party's innocent of fraud is irrelevant to exercise the equitable jurisdiction. I'm saying that the party's innocence goes to the scope of the remedy, if any, against him, and not the existence of the equitable jurisdiction. It's not ipso facto unfair to set aside judgment in favour of a party innocent of wrongdoing in the process leading to the judgment. Aside from fraud, an innocent party may lose the benefit of a judgment in his favour, for example, a default judgment that is set aside for other reasons. And we, with respect, we submit that that is not an apposite analogy. When considering whether to set aside a default judgment, the court is not considering possible complicity in wrongdoing. The court is making a case management decision in the light of the circumstances in which the default judgment was entered and in the light of the merits of the defence. Now, in the next few paragraphs, he gives examples of cases where judgments are set aside because the applicant was not given a reasonable opportunity of appearing. First of all, he cites the clone property case in paragraph 157, and then he deals with a number of the cases that appear in the footnote to that case. We're dealing with fundamental principles of natural justice, a right to be heard, you need to be told that there is a hearing. And his conclusion is at 160. These observations suggest that the necessary minimum requirement for setting aside a judgment in favour of an innocent party is that the party must have notice of the application to set aside and an opportunity to argue against setting the judgment aside. They do not suggest that the law or equity should go further and adopt as a dogmatic proposition that an innocent party may nevertheless lose the benefit of a judgment in his favour procured by fraud, unless he has himself taken part in or been complicit in the fraud. And we would submit that a consideration of cases that deal with setting aside default judgments on grounds that no one was given notice of the application has nothing whatsoever to do with this case. And we would also submit that the conclusion of the last sentence of paragraph 160 is a known sequitur. The cases he's been considering have nothing to do with judgments obtained by fraud and cannot possibly support what he says in that sentence. However, he relies on that to support his conclusion at 162 that the remedy can extend to setting aside the impugned judgment as against a non-fraudulent party to the original proceedings. And then he says at 163 that because BT, which was the defendant, co-defendant, the original action has not been served, he could not set aside the judgment against it. He then asks the question at paragraph 164 as to what principles should the court apply when deciding whether or not to set aside a judgment against an innocent party. And he finds that the court should apply equitable principles in the normal way. I wouldn't call it a matter of the court's discretion. The question is whether it's fair and equitable to exercise the jurisdiction, examining the facts and taking all relevant circumstances into account, including any legacies or other equitable defence. That the party is not guilty of the fraud which taints the impugned judgment is likely to be a factor of considerable importance. And he then applies those principles in 165, and he says, starts by recognising there's some force on both sides of the argument. On the one hand, Mr. Butcher's aggrieved at the prospect of the case against him being revived more than a decade after the trial, and about 13 years after the relevant events, without fraud on his part. On the other hand, the Lindsays are aggrieved that they could be left without a useful remedy after being despoiled of their land and goods in a process in which Mr. Butcher assisted his fraudulent client. And his conclusion at 166 is that it would not be inequitable to set aside the judgment against Mr. Butcher. Essentially, his reasoning is that Mr. Butcher was an experienced LPA receiver and took the risks inherent in taking on such a role. The fact he was prepared to move swiftly increased the risk that the onward sale might be challenged subsequently, and that we get that from paragraph 172. Third sentence, chronology of events supports the proposition that Mr. Butcher was keen to proceed with the sale quickly, and his conclusion is at 177. For these reasons, I'll set aside the judgment of His Honour Judge Bird as against Mr. Butcher also. Now, it's not at all clear what weight, if any, he attached to what he regarded as a factor of considerable importance when reaching this conclusion. That factor of considerable importance being Mr. Butcher's innocence. However, I have to acknowledge that there is no separate ground of appeal criticising the judge's application of equitable principles, if that's the right approach. So I must accept that the learned judge was right to proceed on the basis that general equitable principles apply here, then the appeal on the first ground must fail. So that takes us back to the issue, the juridical nature of the cause of action. We say that the answer lies in Takkar. However, before going there, I should take you briefly to Hip Fung and Junesco and Beard. Hip Fung can be found at tab 4 of the authorities bundle. And Lord Buckmaster's famous dictum can be found at page 45. And sort of about a third of the way down, quarter of the way down, it says fraud or surprise or both are the ground of the application in the present case. The learned judge were in error in thinking that the authority in itself had any direct and present application to the matter they were considering. In all applications for a new trial, the fundamental ground must be that there's been a miscarriage of justice. With no charge.
I'm so sorry, Mr. Ward.
I'm sorry.
What page are you on?
I'm on page 45.
I think there must be
Let me have a look at the hard copy.
the electronic bundle. Is it a different pagination?
I'm on page 45 of the electronic bundle.
It's page 894 of the actual judgment itself. I don't know if that helps.
It doesn't, I'm afraid, because the print I have isn't. It's very interesting. My lord has a completely different version.
I'm very sorry about that.
Don't worry, I'll try and find it. Did somebody say it's page 894?
894, my lord.
In the
It's the last page of this authority, if that helps. So the next page ought to be the first page of Junesco and Beard.
I'll just go back to the index. This is the wrong. It's completely wrong, I'm afraid. You're in Hip Fung Hong.
Yes.
What's happened here? Anyway, carry on.
Thank you.
If necessary, at lunchtime, I'll get the hard copy from my room.
Yes, or we can get someone to. I don't understand.
Yes, my lord has a hard copy in.
I have a hard copy too, which is
That's all right.
a bit unmarked.
I'll use this. It's all right. Yeah.
So it should be tab 4, page 45 being the last page of the authority. And I started to read from about 8 lines in.
Yes, that's
Fraud
right.
or surprise of both of the ground of the application in the present
Yes.
case. The learned judges were in error in thinking that the
Yes.
authority in itself, etc.
I just want to assure you, Mr. Warder, that I've read all of the marked passages in the bundle of authorities in my room. It's just for some reason the electronic bundle doesn't match the hard copy.
Well, that's very helpful. And the key passage, the well-known passage, is just below halfway down the page. A judgment that's tainted and affected by fraudulent conduct is tainted throughout, and the whole must fail. And then we go on to Junesco and Beard, again Lord Buckmaster, and it's page 49, or should be page 49 of the bundle. And at the bottom of that page, in the marked up passage, it says, 4 lines in, were such fraud properly established, I agree with the Court of Appeal in holding that the whole judgment would thereby have been vitiated. Fraud is an insidious disease, and if clearly proved to have been used so that it might deceive the court, it spreads to and infects the whole body of the judgment.
Well, that seems to be against you.
Yes, but in neither case was the court considering the position of an innocent co-defendant. And I would say, actually, looking at it, it begs the question of what the position should be where a co-defendant is innocent. Now, the first discussion of the juridical nature of the right to set aside an action obtained by fraud is TACAR. That deserves careful consideration. It can be found in the authorities bundle at tab 13. I'm sure you do not need to be reminded of the issue in that case. The question for the court was whether someone seeking to set aside a judgment obtained by fraud needed to demonstrate that he or she couldn't have uncovered the fraud by the exercise of reasonable diligence. A seven-judge court unanimously held that the law had taken a wrong turn and that there were no reasonable diligent requirement. There were two majority judgments delivered, the first by Lord Kerr and the second by Lord Sumption. Lords Hodge, Lloyd Jones and Kitchen agreed with both. The more important judgment from my perspective is Lord Sumption's judgment. But I need to show you what Lord Kerr had to say first. And one can pick it up at paragraph 43 of the judgment at page 317. He cites Lord Bingham in the HIH casualty case. Fraud is a thing apart. This is not a mere slogan. It also reflects an old legal rule that fraud unravels all. Once fraud is proved, it vitiates judgment, contracts and all transactions whatsoever. That's Lazarus Estates per Lord Justice Denning. Parties entering into a commercial contract will no doubt recognise and accept the risk of errors and omissions in the preceding negotiations, even negligent errors and omissions. But each party will assume the honesty and good faith of the other, absent such an assumption that it would not deal. And in the subsequent paragraphs, it focuses on the question of whether or not there is a due diligence requirement. And I don't think we should go through those paragraphs, but just take you to the conclusion at paragraph 54. Where he says this: for the reasons I've given, I don't consider that Etoile and Bracco are authority for the proposition that in cases where it's alleged that a judgment was obtained by fraud, it may only be set aside by the party who makes that application can demonstrate that the fraud could not have been uncovered with reasonable diligence in advance of the retaining of the judgment. If, however, they have that effect, I consider they should not be followed. In my view, it ought now to be recognised that where it can be shown that a judgment has been obtained by fraud, and where no allegation of fraud has been raised at the trial which led to that judgment, a requirement of reasonable diligence should not be imposed on the party seeking to set aside the judgment. Now, in the course of his analysis, he doesn't really deal with the juridical nature of the right. He proceeds on the basis that in line with previous authority, including decisions in Australia and Canada, there is such a right. And at the risk of stating the obvious, he doesn't deal with the position of an innocent party. However, he did go on to consider Highland in paragraphs 56 and 57, and he regarded Highland as setting out the relevant principles to be applied in such a case as this. And we would say, subject to the debate we had a few minutes ago, we would say that Highland reinforces the proposition that the judgment should only be set aside against the fraudster and not innocent parties. Now, Lord Sumption also induced the principles in Highland, which he regarded as providing an important safeguard, reducing the risk of extravagant or frivolous litigation. And we get that from paragraph 67 of his judgment at page 324. Where he recognised the risk of frivolous or extravagant litigation, but like other members of the court, I think that the stringent conditions set out by Lord Justice Aikins in Royal Bank of Scotland, combined with the professional duties of counsel, are enough to keep it within acceptable limits. More important from the appellant's perspective, my lords, is what Lord Sumption says at paragraphs 59, 60 and 61.
Just before you go to that, I mean, it's not relevant for our purposes, obviously, but given that we're examining the state and law, when he says combined with the professional duties of counsel, what happens if the litigant is unrepresented by counsel?
Well, then that safeguard doesn't apply. I mean, If litigant is unrepresented, and therefore there's
Seems to be an odd state of the law. It's dependent upon professional representation in circumstances where parties are not necessarily.
I think I would just read what he says as just an added safeguard. The real principle being what Lord Justice Aitken says as being the safeguard. But in many cases, the litigant will be represented by counsel, and to that extent, there is that additional safeguard.
Okay.
So 59, 60 and 61. Subject to what follows, I agree with the judgment of Lord Kerr. I had some observation to my own only because the disorderly state of the authorities is apt to make the question before us appear more complicated than it really is. In my view, the basic principles on which this case falls to be decided are reasonably straightforward. An action to set aside an earlier judgment for fraud is not a procedural application, but a cause of action. As applied to judgments obtained by fraud, the historical background was explained by Sir George Jessel and Flower and Lloyd. Equity has always exercised a special jurisdiction to reverse transactions procured by fraud. A party to earlier litigation was entitled to bring an original bill in equity to set aside the judgment given in that litigation on the ground that it was obtained by fraud. Such a bill could be brought without leave because it was brought in support of a substantive right. If the fact and materiality of the fraud were established, the party bringing the bill was absolutely entitled to have the earlier judgment set aside. In this respect, an original bill differed from a bill of review on the basis of further evidence, which was essentially procedural and did require leave. After the fusion of law and equity in 1870, the procedure by way of original bill was superseded by a procedure by action on the same judicial basis. The cause of action to set aside a judgment in earlier proceedings for fraud is independent of the cause of action asserted in the earlier proceedings. It relates to the conduct of the earlier proceedings and not to the underlying dispute. There can therefore be no question of cause of action estoppel, nor can there be any question of issue estoppel, because the basis of the action is that the decision of the issue in the earlier proceedings is initiated by the fraud and cannot bind the parties. If the claimant established his right to have the earlier judgment set aside, it would be of no further legal relevance to any judgment. It follows that res judicata cannot therefore arise in either of its classic forms. So he makes it clear, we say in these paragraphs, that the party against whom a judgment has been obtained by fraud has a substantive right to set aside that judgment. It is a cause of action. And that, we say, suggests strongly that the judgment will only be set aside as against a fraudster and not against an innocent co-defendant. Note in passing, please, what he says in paragraph 63, to the effect that only a deliberate decision not to investigate a suspected fraud or rely on a known one could preclude the innocent party from raising the matter in a subsequent cause of action. I mention this because the Privy Council has more recently in Finzi refused to adopt this approach, and we rely on Finzi as providing further support for the proposition that fraud unravels all is not some sort of magic wand that can be used to have a second bite of the cherry against an innocent party. I will come to Finzi shortly, but putting it another way, to use Lord Sumption's terminology, the Lindsays have no substantive rights against Mr. Butcher. And turning back to Lord Sumption's observations about the victim of the fraud having a substantive cause of action, even though the learned judge refers to paragraph 60 of Lord Sumption's judgment at paragraph 109 of his judgment, which you find on page 63. He doesn't deal with what Lord Sumption said about the right to set aside judgment being based on a substantive cause of action. And before moving on, I should perhaps show you briefly what Lord Briggs had to say. His view was not supported by the majority, but he too proceeds on the basis that there is a substantive cause of action vested in the victim of the fraud. And we can pick up his judgment page 324 of the bundle. Note, the introduction is notable. This appeal turns on the outcome of a bare-knuckle fight between two important and long-established principles of public policy. The first is that fraud unravels all. The second is that there must come an end to litigation. I will call them the fraud principle and the finality principle. And we will obviously submit that it's the finality principle that wins on the facts of this case. And we can pick it up at page 328, where he says at paragraph 81, the starting point is clearly to recognise that the right to have a judgment set aside for fraud is a distinct cause of action recognised by the common law, like a right to set aside a contract obtained by fraud, which is not inherently conditional upon any requirement for the exercise of reasonable diligence in the proceedings leading to the impugned judgment.
So we see immediately one difference between Lord Briggs and Lord Sumption is that Lord Briggs characterises this as a common law cause of action, whereas Lord Sumption characterises it as equitable.
Yes.
Which do you say it is?
Well, I have to be bound by Lord Sumption and the majority judgment.
So in that respect, you say that Lord Briggs is in error.
I'd say Lord Sumption is to be preferred, yes.
So it is an equitable jurisdiction.
Yes.
You say it's a substantive right, it's a cause of action to put it in modern terms, but nevertheless the basis of it is equity, not common law.
I agree. That's the way I put it. Thank you. So, just so you know, where Lord Briggs departed from the majority was that in thinking the court could interfere with the exercise of the substantive right if satisfied that such exercise was abusive. And for your note, we don't need to look at it. It's paragraph 85 on page 329. Now, Takkar was followed by the Court of Appeal in Tinkler.
Before we leave Takkar, I just ask this. It doesn't seem to have been considered at all by the Supreme Court, but in Takkar there were 3 defendants in the first trial and 3 defendants in the second action. As I read the facts, the fraud is alleged against the second and third defendants. Do we know anything about whether there was an application? Well, clearly the application set aside the judgment against all 3 defendants. Was any consideration given to that at any level in the case, do we know? I think you were in the case, weren't you?
I think I was in the case, and I did do the subsequent hearing to set aside the judgment. And I'm afraid I've completely forgotten about the number of defendants. I need to have a look and have a think.
Yeah.
But certainly that issue did not arise at any stage of the proceedings. It was essentially an application to set aside the judgment because of the fraud of the Christians. So Takkar was followed by the Court of Appeal in Tinkler. I've already mentioned this when commenting on paragraph 92 of the judgment. I should now take you to the judgment of the Master of the Rolls. That can be found at Authorities Bundle tab 14. And we can pick it up at paragraphs 12 and 13 on page 344. Paragraph 12, Master of the Rolls says this: in modern terms, we can perhaps regard the action to set aside a judgment for fraud as akin to an action for deceit. The only significant differences are the court, rather than the opposing party to the first action, has to be shown to have been deceived. Deliberate dishonesty is required, and materiality rather than simple reliance must be shown. If the elements are made out, misrepresentation or misleading conduct, made or undertaken fraudulently, with reliance for deceit and materiality for an action to be set aside a judgment, the contract or the judgment can be rescinded or set aside. The precise analogy is not important. It's however important to understand what the court is doing in trying a freestanding action to set aside a judgment for fraud. It's quite different from an application to adduce fresh evidence.
So, what do you say to the analogy that's been drawn with deceit there? Because deceit is a common law action.
Yes.
whereas you've accepted that the jurisdiction we're concerned with is equitable. And it might be thought that is not matters of pure legal archaeology. It is relevant because equity always took a broader view of fraud than the common law.
It doesn't in this case, because when we go on to look at clone, it's not equitable fraud in the broader sense that can be relied on to set aside a judgment. It has to be fraud in the common law sense, even though it was originally an equitable jurisdiction being exercised. It's very clear, as I will submit, that the jurisdiction to set aside for fraud is on the narrow common law definition of fraud, or not a wider equitable interpretation of it.
So speaking of myself, and I don't mean any disrespect to the Master of the Rolls, I'm just wondering how juridically it really is akin to an action for deceit, because what he then qualifies it by saying, it might be said to be such significant differences, I'm not sure the analogy really is helpful to the analysis, because the fundamental point he's making, which is undoubtedly correct, is that it's the court which is being deceived. Now, in an action for deceit, where you have two private parties suing each other, presumably one of the reasons why they're suing each other is because they want monetary compensation.
Yeah.
That's the end result. But the court isn't going to be asking for monetary compensation from anyone. The court is interested in upholding other values, in particular the integrity of its own processes.
Yeah.
So if the court has been deceived by X and Y, and has given a judgment in favour of not only X but also of Y, speaking for myself, I don't understand why drawing an analogy with the action for deceit really helps us.
I think he was, I'm not sure how much I can help you in answer to that question, but I think he was really echoing what Lord Sumption was saying to tackle.
I see that. Of course, one readily understands that judicial statements are made in the context of the particular case that was before the court on that occasion, in both in Takar and in Tinkler. So I can well understand why the passages you've shown us were set out in those judgments, but I'm not sure how much it's going to help us in analysing the critical issue we have to decide, which I think everyone accepts, has never been the subject of authority before.
No.
And when we do have to face that critical issue in the present case, as I see it, the question for us is, if a court has been deceived by X, and that has had the operative effect of causing a judgment to be given in favour not only of X, but also in favour of an innocent party Y,
Yes.
can the judgment in principle be set aside also against Y?
Yes.
And you say, no, there are no circumstances in which it can be, because the jurisdiction simply doesn't arise.
Yes.
That may be right, but in answering that, I'm not sure it's helpful to us to be shown a passage which says that the course of action is analogous to an action for deceit, because I'm not sure in the present context it is.
I accept that maybe not that helpful, but I would say that what Lord Sumption says in Takar is helpful.
I understand.
And ought to be given careful attention.
Thank you.
Before moving on from Tinkler, and just for your note, I don't think we need to look it up, but in paragraphs 20, 31, 51 to 53, pages 346, 349 and 354, again the Court of Appeal puts considerable weight on Lord Justice Aiken's judgment in the Highland case. My lords, we say that the other authorities relied on by my own friend below don't help him. We say, on the contrary, they support this analysis. The first is the High Court of Australia decision of cloned property. Far from concluding that judgments can be set aside against non-enforcement parties, the court expressly held that it's a necessary and mandatory requirement of the cause of action to set aside a judgment alleged to have been procured by fraud, for fraud actively to be alleged and proved. And the decision can be found in tab 12 of the authority standard. And draw your attention in particular to paragraphs 1 and 2 on page 264, where it says these appeals concern the equitable power of a court to set aside its own perfected judgment, namely its formal orders, whether in the form of a judgment strictly so called or a decree, order, or sentence. The primary judge in the Supreme Court of South Australia set aside a perfected judgment of that court based on misconduct not amounting to fraud. An appeal to the full court of the Supreme Court of South Australia was dismissed by majority. The essential questions in these appeals are whether the power of a court to set aside its perfected judgment extends to each of the following circumstances. 1, misconduct by the party who succeeded the trial which doesn't amount to fraud. And 2, whether the unsuccessful party failed to exercise reasonable diligence to discover the fraud or misconduct during the earlier proceedings. The answers to each of these questions are as follows. First, the general power of a court to set aside its perfected judgment requires actual fraud, although there are other discrete grounds to set aside a perfected judgment, which weren't an issue in these appeals. Secondly, it's not a precondition to the exercise of the power that the party seeking to set aside judgment exercise reasonable diligence to attempt to discover that fraud during the earlier proceedings. Then we can pick it up in paragraph 55 on page 285. And just for your note, I don't think I need to take you to it, but the learned judge in his judgment relied on the preceding paragraph, which is paragraph 54. 55, they say this. The general power to set aside a judgment on the ground of fraud required actual fraud. The essence of the action was fraud. The general ground of fraud was not diluted to allow, for instance, the judgment to be set aside for misconduct, accident, surprise, or mistake. This point was made pellucidly in 1867 in Patch and Ward. In that case, as Lord Cairns observed, the application was not brought on the basis of either category of the Bill of Review, either error of law or fresh evidence discovered since the decree. Rather, it was brought upon the basis that the decree was obtained by fraud. His Lordship explained it was necessary that fraud be actual fraud, the person chargeable with it acting in order to take an undue advantage of some other person for the purpose of actually and knowingly defrauding him. Similarly, Sir John Rolt, after observing the particular ground of review in case the foreclosure was inapplicable, remarked the claim to set aside the order for fraud. I think for the reasons which have been given by my learned brother, the fraud must be actual positive fraud and meditated and intentional contrivance to keep the parties and the court in ignorance of the real facts of the case and obtaining that decree by that contrivance. Mere constructive fraud not originating in actual contrivance, but consisting of acts tending possibly to deceive or mislead without any such intention or contrivance, would probably not be sufficient. At all events, I think could not, after such a delay as occurred in this case, be deemed sufficient to set aside the order which had been made. What, therefore, the appellant has to do is to satisfy the court that the decree was obtained by the positive and actual fraud and contrivance of the party obtaining it. And if we go over the page, 56, the power of a court of equity to rescind its own decisions for fraud was unaffected by the Supreme Court Judiciary Act. Indeed, the power expanded to apply also to perfected common law judgments, the execution of which can no longer be restrained by a common injunction. As an exception to finality, the power survived the statutory regime which defined the powers of appellate courts because it was and remained a narrowly defined exception and therefore tolerable. In contrast, the broad equitable Bill of Review didn't survive as a separate procedure alongside the appellate jurisdiction finally created by the Supreme Court Judiciary Act, because it would have stultified the operation of the statutorily defined principles of finality, including the conditions to be met before an appellate court could exercise the power to order a new trial. the narrow, paragraph 57, the narrow scope of the general power of a court to rescind a judgment for fraud was reiterated after the Supreme Court Judicial Act and the Act of Peerage. In the course of considering whether a declaration of legitimacy could be set aside, Lord Wilberforce compared an application to a court to set aside its own judgment and said that equitable fraud or lack of frankness would not suffice to set aside a judgment, and that only fraud in a strict legal sense will do. Similarly, Lord Simon of Glasdale said that lack of frankness or an ulterior or oblique indirect motive is insufficient. And then we can take it up, I think, at paragraph 62. Oh, so at 60 we ought to be referred to, although there might be doubt what was meant by Lord Buckmaster's reference in Pitfong Form. To surprise, there's a more fundamental reason why this case doesn't assist. As the House of Lords later observed in Genesco and Beard, the Privy Council in Hipfung Hong had not been concerned with the power of a court to set aside its own decision. That was an appellate court for the grant of a new trial. And at 62, the power to set aside the Supreme Court's own decision, with which Hargrave AG was concerned, was the narrower power that was historically distinct from an appellate court's power to set aside orders of a court below and order a new trial. Before that narrower power could be exercised in this case, it required a pleading and proof of actual fraud. Blair's alternative contention was that even if actual fraud was required, it could still succeed. That contention should be rejected. Fraud needs to be clearly pleaded and proved. It was not. Unsurprisingly, the factual findings of Hargreave AG and the full court did not address and were not adequate to establish actual fraud. Now, note the emphasis we say on equity providing a narrowly defined exception to the principle of finality. And we say that's impossible to reconcile with the general power exercisable on equitable principles to set aside a judgment obtained by fraud against not only the fraudster but also an innocent party. And there's no difficulty, we would submit, in just setting aside the judgment against the fraudster. It's no different from when one of a number of co-defendants brings a successful appeal to the Court of Appeal, and the judgment against him or her will be set aside and either a new trial ordered or that's the end of the matter. But the judgment survives against the co-defendants unless the ground of the appeal is, of course, something that goes to the heart of the whole judgment, in which case the judgment will fall against all of them.
In a case like the present, on your submission, could the claimants have sought to appeal against Mr. Butcher out of time? Well, first of all, could they have sought to appeal? Was that the appropriate course they should have taken? And then that may raise questions about extensions of time.
By that you mean appealing the original decision of His Honour Judge Bird?
Yeah, on the basis that the jurisdiction with which we're concerned about a court setting aside its own judgment on grounds of fraud was not available. So what I'm asking you is, would the alternative course, which is alluded to in the authorities, of appealing?
But if they had fresh evidence that was sufficient,
it would be that the original judgment was procured by fraud, although not Mr. Butcher's fraud.
Yeah.
So in principle, would you accept that, or would you not accept that there would have been an appeal available, albeit there might be important questions for the court to consider about whether to grant an extension of time after such a long time?
I think in principle I probably have to accept that. But can I just sort of
course
think about
yeah,
it while I'm
yeah.
making
You
my
won't be held to that. But I'm just trying to see analytically where the present jurisdiction fits into the overall structure of the legal system.
I think I would
I mean,
difficulty seeing. I'm sorry.
That point may require further research if we're going to pursue it, because there was a phase in the authorities, as I recall it, my recollection may be faulty, that it was suggested at one stage that the remedies of a fresh action by fraud and an appeal were, as it were, both available equally, and I thought that there'd been a subsequent correction in the authorities to say no, they're distinct remedies for different circumstances. So if you are saying original judgment wrong in law, obviously that's an appeal. Fresh evidence, again, that's a matter for appeal. If it's in the sense of evidence that couldn't reasonably be discovered, etc., and the Carlson you like. But if the fundamental proposition is this judgment was obtained by fraud, I thought the position we'd now arrived at is that you have to bring a fresh action, not an appeal. But as I say, my memory may be at fault.
I entirely agree that people used to think you could go one of two routes. I also entirely agree that now the people think that by far the better route is fresh action. I'm not sure, I need to look it up, I'm not sure that an appeal route isn't open to. You may have circumstances where you have fresh evidence which engages fraud, but engages other issues which the Court of Appeal need to deal with if you're seeking a new trial, other issues, and maybe they're sufficiently intertwined. You can't just separate out the fraud part of it and say I'm bringing a fresh cause of action with that, and I'll leave the other points I want to rely on to go to the Court of Appeal. So I think we'll check it, but I think the better view is you should go by way of fresh action, but I don't think it's required.
I see. Thank you.
But I may be wrong.
I suppose what I'm interested in is where we end up. If you're right, is that really the end of the road? Where a previous court judgment has been obtained by fraud, albeit by X rather than by Y, but also in favour of Y, is the net result that the judgment just has to stand in favour of Y and nobody can do anything about it? Or is it that if there is any remedy at all, it would have to be by way of appeal, and therefore the jurisdiction with which we're concerned is not available?
That's how I would put it. I would say any remedy is available by way of appeal. This jurisdiction is not available as against innocent parties.
Yes. I suppose, yes, all right.
Can I confuse things by taking this a step further, which is, you talked about going to see what the juridical basis of this is, and in TACAR there's quite a long discussion about, as I read it, about the relationship between setting aside a judgment on the basis of fraud and the broader jurisdiction about all around res judicata, abuse of process, issue estoppel and cause of action estoppel.
Yeah.
So if you step back from this a moment, because this is not a case where a claimant has obtained a judgment by fraud. This is a case where a claimant has failed in a claim because of the fraud of one of the three defendants. I want to ask, well, what and remember the cause of action originally was this mortgage is unenforceable because of some agreements or agreements that were made between the lender and the borrower.
Yes.
The new cause of action is, in a sense, entirely different, at least against Outlook. It's that the mortgage is invalid because it was procured by fraud.
Yes.
What is there to stop the claimants here simply bringing a new action? And that might tell us something about what we need to show in order to set aside the judgment. So what stops them bringing a new claim against Mr. Butcher?
Well, certainly late she's,
Well, that's the second.
which is the second ground. I would say Henderson would bite on an attempt to bring a second action immediately after the first.
Even and if one can I just take us back to the passage in TACAR which dealt with this question?
Tab 13.
Yes, and I think it's where they're discussing Lord Sumption in Virgin Atlantic.
Right.
Let's find the passage. It's in Lord Carr in there.
Page 322, I think it is, Ronald.
No, that's Lord Sumption. I think it is.
It'll be earlier. So the relevant passage in Lord Carr starts at 317. It's some time after that.
He's actually considering this at an earlier stage of this judgment, paragraph 22.
Oh, thank you.
There is somewhere set out entirely what Lord Sumption. Oh, here it is. It's paragraph 26. Lord Sumption in Virgin Atlantic refers to what Arnold and National Westminster Bank is authority for.
Yes.
So it seems to me that the analysis in relation to Mr. Butcher would be something along the lines of the cause of action estoppel, because the cause of action against him was one for trespass, I think.
Yes.
Basis the mortgage was unenforceable. The same cause of action could be said to be being brought now, trespass, but for a different basis, either charges invalid. But what Lord Sumption says about that is, cause of action estoppel is absolute in relation to all points which had to be and were decided, but cause of action estoppel also bars the raising in subsequent proceedings of points essential to the existence or non-existence of a cause of action which were not decided because they were not raised in the early proceedings, if they could with reasonable diligence and should in all the circumstances have been raised.
Yes.
Now, what the case actually goes on to consider is whether that particular caveat applies where the first judgment was obtained by fraud. But there looks to be a broader principle that if it's not obtained by fraud, then you can still start again, provided that the basis on which you're bringing your new action was not reasonably available to you at the time of the first action.
Subject to it being a Henderson abuse, as I understand it.
That's what this is dealing with, isn't it? It's not an abuse if in all the circumstances it neither could nor should have been brought, which is the Henderson test, I think.
I think Lord Sumption himself, doesn't he deal with this as well? Yes, it's paragraph 62. It refers to Henderson. The rule originally stated that parties precluded from raising subsequent proceedings matters which should not but should have been raised in the earlier ones, is commonly treated as a branch of the law judicata. There's the same policy objectives and the same preclusive effect. But it's better analysed as part of the juridically distinct but overlapping principle, which empowers the court to restrain abuse of its process. The relationship between the two was examined in Virgin, whereas res judicata is the rule of substantive law, abuse of process is a concept which informs the exercise of the court's procedural powers. These are part of the wider jurisdiction of the court to protect its process from wasteful and potentially oppressive duplicative litigation, even in cases where the relevant question was not raised or decided on the early occasion. Since the decision of the House of Lords in Arnold, has been recognised that where a question was not raised or decided in the earlier proceedings, but could have been, the jurisdiction to restrain abusive relitigation is subject to a degree of flexibility, which reflects the procedural character. So I would say that if the claimants had attempted to have another go at Mr. Butcher shortly after the first judgment, Henderson points would and could have been taken against them.
Yes, and I think what's implicit in paragraph 62 is that we're dealing not only with cause of action estoppel, but also issue estoppel. Right. So, for example, if the new cause of action is not identical to the earlier one, but nevertheless an issue could have been, and with reasonable diligence should have been, ventilated in the earlier proceedings, then it's not enough to say, well, I'm now bringing a different cause of action.
Exactly. Right. That's how I see it. I don't know whether that helps.
Well, but in this case, it can't be said that the matters which are now brought, i.e. the fraud of Mr. Fradgley, could, with reasonable diligence, have been brought before the first action, are they?
There's no evidence to suggest that it could, no. Well, actually there is. When I come to laches, there is, because they had the relevant documents. So there would have been a real issue there. They had the relevant documents some 2 years before the actual trial, before his Honour Judge Bird, and anyone looking at those documents would have realised that they'd been the victims of fraud. So yes, would have been an issue on that very point.
The case isn't, I think, put on this basis. It's put solely on the basis of an action to set aside on the grounds of fraud.
Yes.
But this may matter. Analytically, it may matter. It may be a point in your favour. I don't know. Because you may say that what Lord Sumption has emphasised is that the jurisdiction with which we're currently concerned is a jurisdiction which arises as a matter of substantive right.
As against the fraudster.
Yeah,
That's
that's the issue we have to decide. But the important point that a number of the authorities have emphasised, clone property, I think, also makes this point, is that the jurisdiction which you say is a narrow one, but however wide or narrow it is, one thing is absolutely clear, I think, is that it's a matter of substantive law,
Yes.
not about procedure, whereas the jurisdiction to prevent an abuse of process, Henderson and so on, as Lord Sumption says, reflects its procedural character.
Yeah.
Now, that may be important
That's very helpful.
to your I don't know who's right.
I don't know whether it is. I agree with that analysis.
Thank you.
And I would say it is helpful to me because as you know, there are the two competing principles: finality on the one hand, and setting aside for fraud. And all the courts, all the authorities we've seen so far, have proceeded on the basis that the setting aside for fraud is a very narrow exception, and therefore query why on earth should that extend to an innocent party who is not in any way involved in the fraud.
And it might be said, I'm not saying I agree with this proposition, but it might be said that if that doesn't mean that it's the end of the road, that if in principle the law can correct an earlier injustice through other means,
Yes.
but it may be that they're subject to various caveats and may be more perhaps discretionary in nature, at least it shows that the court should not necessarily be inclined to broaden what you say is a narrow jurisdiction in order to correct injustice, because in principle there would be other ways of correcting.
Quite so. There's no need to narrow this jurisdiction. Sorry, no need to broaden this jurisdiction when there are other routes would have been open.
I see your submission. Yes.
Thank you. So I think where we got to, I've done clone. I was going to just take you to the extract from Margummer and Lehane that the judge relied on to support the respondent's argument. And it's from paragraph 12.145 of the textbook, which is helpfully set out in the judgment at page 63. That's paragraph 108. My own friend relied on this below. And the extract from the textbook says this: as Lord Buckmaster put it in Genesco and Beard, fraud is an insidious disease, and if used to deceive the court, spreads to and infects the whole body of the judgment. The suit in equity to impeach a judgment, whether given at law or in equity, is a separate proceeding. It takes on none of the characteristics of the proceedings which gave rise to the judgment under impeachment, but rather there is a personal obligation to give up the fruits of unconscionable conduct. Fresh evidence is brought forward and the investigation is new and not appellate in character. And I, of course, rely on the phrase, there was a personal obligation to give up the fruits of unconscionable conduct. I again say that focuses on the fraudster and isn't sufficiently wide to extend to innocent third parties. And a similar point can be made by the other extract from Marr that he cites at paragraph 123 of his judgment, at page 65 of the call. Where the textbook says this: where appropriate, the court will grant a proprietary remedy to restore to the plaintiff property of which has been wrongly deprived, or to prevent the defendant from retaining a benefit which is obtained by his own wrong. Again, I would submit that focuses on the wrongdoing by the fraudster.
Sorry, where were you reading?
I'm sorry, my lord. I was reading from paragraph 123 of the judgment on page 65.
This is, I think, quoting Mr. Justice Millett in Lonro, and
Yes.
where he in turn cites Margummer and Lehane, second edition.
Yes. So finally, on the authorities, we need to look at the Privy Council decision in Finzi. And the importance of this case is that it rejected Lord Sumption's overture remarks in paragraph 63 of his judgment, and in so doing made it clear that the ability to prove fraud is not some sort of magic wand or open sesame which opens all doors. You can find Finzi at tab 15 of the authorities bundle. Start with the head note. The claimant brought a claim against the defendant seeking to set aside various judgments and consequential settlements on the ground they'd been procured by the defendant's fraud. The judge dismissed the claim as an abusive process, finding that when the claimant entered into the final settlement agreement, which put an end to all outstanding claims between the parties, he had had all the information upon which he was now relying to support his claim for fraud, and that therefore the allegations of fraud could and should have been raised in the earlier proceedings. The Court of Appeal of Jamaica refused the claimant's application for permission to appeal. The claimants appealed against the Court of Appeal's decision, contending among other things that it could not be said that he should have raised the allegations of fraud in the earlier proceedings because he had made no deliberate decision not to raise them. On the claimant's appeal, advising the appeal be dismissed, where a claimant brought an action to set aside an earlier judgment or settlement on the ground it had been procured by fraud, the burden would be on the claimant to establish, one, that the evidence of fraud was new in the sense it had been obtained since the judgment or settlement, or two, if the evidence was not new in that sense, any matters relied on to explain why the evidence had not been deployed in the original action. But furthermore, where the evidence of fraud was not shown to be new in that sense, the claim was likely to be regarded as abusive unless the claimant was able to show a good reason which had prevented or significantly impeded the use of the evidence in the original action. That thus an action to set aside judgment or settlement for fraud in reliance on evidence of fraud that was not new might be found to be an abusive process, notwithstanding that the claimant had not made a deliberate decision not to deploy that evidence in the original action. That in the present case, one, there was no reasonable basis for impugning the judge's finding that when the claimant entered into the final settlement agreement, he had had all the information on which he was now relying to allege fraud, and two, the claimant had offered no explanation for why he had not deployed that information in the earlier proceedings, and that accordingly there were no grounds for disturbing the judge's assessment that the action was an abuse. And the relevant analysis can be found at paragraphs 59 to 76 of Lord Legate's judgment, who delivered the judgment to the board. You can pick it up at paragraph 59 on page 373. There's been a discussion of Park. I don't think we need to look at that. 59 says this: the board doesn't doubt that Park was rightly decided on its facts, but would not adopt the approach of the English Court of Appeal in that case to the question of abuse. The sole basis for that approach was what was said by Lord Sumption and Tacker. In the opinion of the board, the statements of Lord Sumption on which the Court of Appeal relied don't bear the weight put on them. It's important not to lose sight of the basic tenets of common law reasoning, that every judgment must be read in context, by reference to what was in issue in the case. And it is only the ratio of the decision which establishes a precedent and not over to dicta. All too often advocates treat the analysis of cases as if it was simply an exercise in looking at the language used by judges, forgetting that it is not particular verbal formulations that make the common law, but the principles on which the actual decisions in cases are based. As Mark Leeming, the judge of the New South Wales Court of Appeal, has observed in a perceptive note on the Tackart case, Lord Kerr's judgment is an excellent example of how cases should be read, and his careful exposition of how the statements in the two Owens Bank cases didn't bear on what was actually issued in those cases. And then we pick it up at 62. The Supreme Court didn't receive argument on nor have to apply their mind to that question, let alone decide it. The judgments must be read in that light. And the Lord Judge Sumption 65 distinguished between the proposition that an action to set aside a civil judgment must be based on new evidence and the proposition that that evidence must not have been obtainable by reasonable diligence. While rejecting the second proposition, he described the first as well established, but nowhere in its judgment did Lord Sumption consider separately, one, the proposition that the evidence on which the action set aside judgment is based must have been obtained since the early proceedings, and two, the proposition that the evidence must be new only in the sense that it was not adduced in the early proceedings, even though the claimant already had it. It's a mistake in those circumstances to treat what Lord Sumption said as authority on a point that he did not need to and did not address. And then at 65, let's say this, perhaps 64. Leaving aside the difficulties created by the decision in Zurich Insurance, Lord Sumption's reasoning is an orthodox statement of the test for rescission of a contract for misrepresentation, but his discussion appears to leave no separate space at all for the Henderson principle, or what he had aptly described as the wider jurisdiction of the court to protect its process from wasteful and potentially oppressive duplicative litigation, even in cases when the relevant question was not raised or decided in the early occasion. In effect, the approach suggested by Lord Sumption amounts to saying that an action set aside for judgment for fraud would only be an abuse of process in circumstances where there was a good defence to the claim anyway, because the claimant didn't rely on the fraudulent misrepresentation having taken a deliberate decision either not to investigate a suspected fraud or not to rely on a known one. On this approach, the new action should only be prevented from proceeding if it would have no real prospect of success at trial. In the board's view, this approach gives insufficient weight, indeed on analysis it gives no weight at all, to the strong public interest of achieving finality in litigation. Were the transaction which the claimant is seeking to unmake as the entry of judgment by a court or the making of a settlement agreement, there is a wider principle at stake than in the ordinary case of a claim to rescind a contract. In the case of an ordinary contract, the only principle is at stake is that the agreement should be kept. But a settlement agreement engages not just this principle, but the principle of finality in litigation, since its very purpose is to put an end to further disputation in the same way as a judgment. One way in which the principle of finality is protected is by means of the court's procedural power to prevent abuse of its process. The court can see no justification of exempting actions alleging that a settlement or judgment was obtained by fraud from the scope of that protection in cases where the evidence relied on was already known to the claimant at the time of the settlement or judgment. And if you then pick it up to paragraph 70, if the matters relied on to support a claim that a judgment or settlement was obtained by fraud were known to the claimant during the early proceedings, but were not relied on or not as evidence of fraud in those proceedings, the reasons why fraud was not alleged in these proceedings will not generally be within the knowledge of the other parties. You can only speculate about what those reasons might be. In principle, there's a variety of possibilities. One is the possibility just mentioned didn't occur to the claimant at the time the matters in question showed fraud, but the claimant now sees them differently. Another is that the claimant suspected fraud but didn't think at the time there was a case of fraud worth pursuing. The third possibility is the one canvassed by Lord Sumption. The claimant knew that the other party was acting deceitfully, but took a deliberate decision not to allege fraud, perhaps for tactical reasons. In reality, there's no sharp divide between these possibilities, which are better conceived as points on a continuum. Which of these possibilities, if any, however, accounts for why the material now said to show fraud was not deployed in the original action is unlikely in the board's opinion to have much bearing on whether the claim is an abuse. The question whether material should have been deployed in the original action is an objective one, which in principle should not depend on the subjective beliefs and motives of the party now alleging fraud. In answering the question, a central consideration must be whether there was any significant impediment to using the material to advance a case of fraud in the original action. If there was not, then prima facie at least, deploying the material to advance such a case on that occasion is applying Lord Sumption's formulation, something which the law would expect a reasonable person to do in his own interest and in that of the efficient conduct of litigation. Moreover, given that the question of what information the claimant had during the early proceedings and why any such information was not deployed are matters peculiarly within the claimant's knowledge and often veiled by legal professional privilege, fairness requires that the burden of proving such matters should lie with the claimant. The board thus considers that where a claimant relies on evidence not adduced in the original proceedings to allege that a judgment or settlement in those proceedings was obtained by fraud, the burden is on the claimant to establish, one, that the evidence is new in the sense it has been has been obtained since the judgment or settlement, or two, if the evidence is not new in this sense, any matters relied on to explain why the evidence was not deployed in the original action. Furthermore, where the evidence is not shown to be new in this sense, the claim is likely to be regarded as abusive unless the claimant is able to show a good reason which prevented or significantly impeded the use of the evidence in the original action. And finally, we go on to the conclusion, paragraph 76. There are sayings mentioned in Tacker that fraud is a thing apart and that fraud unravels all. But allegations of fraud are not to be regarded as some kind of open sesame, which only have to be uttered to enable a party to engage in a new round of litigation of disputes that have been compromised or decided. In this case, it's clear that well before he entered into what was meant to be a final settlement of all outstanding claims, Mr. Finzi had all the material on which he now relies to allege fraud, and that he had ample opportunity to deploy it in the earlier proceedings if he thought fit to do so. He's offered no explanation of any merit for the fact that he's not. The board is satisfied that the judge made no relevant error of law, and that in the circumstances there's no real prospect of disturbing the judge's assessment that this action is an abuse of process. So that does not provide support for the proposition that a judgment obtained by fraud should be set aside against innocent parties as well as the fraudster. And yet again, emphasises the narrowness of the jurisdiction. And if the emphasis or focus remains on the juridical nature of the right to have such a judgment set aside, it becomes clear that the judgment should be set aside only against the fraudster. And of course, I do accept that the court is concerned to protect its own process, but this action, the second action to set aside grounds of fraud, is brought by the victim. If no action is brought, the action stands.
I'll just ask this: the whole tenor of the judgment in Finzi is directed not to the substantive nature of the cause of action, which is the core of your submission, but about a different question: whether an application to set aside would be an abuse of process, which is the procedural aspect.
Yes.
So it's not really concerned with what you need to prove and what you need to show in order to establish a right to set aside a judgment, other than the procedural aspect that's tacked onto it.
What's important from my perspective, I think, is this. It just be able to wave the wand of fraud doesn't open all doors. Doesn't mean you can bring a subsequent action even if you had the relevant material at your hands before, even if we may not have seen the significance of that material before. So it shows the court imposing restraints on the circumstances in which a second action can be brought to set aside an action on the ground that was obtained by fraud. And we would submit that the law would be in a remarkably unbalanced state if the true position was that a victim of fraud couldn't get redress because he had access to the relevant material before the original trial, but by way of contrast, the innocent co-defendant remains completely exposed to the consequences of a subsequent successful action brought by the victim. And what the court is doing in Finzi is effectively reiterating the importance of finality of judgments. You can't just come along and have another go because you've re-examined the material you've had before and decided you've now got a good cause of action in fraud. Now, if the principle of finality is that strong, why does this jurisdiction, which is said in every authority we've looked at, other than the early ones of Hipfung and Genesco, to be a narrow exception? Why? One is entitled to ask rhetorically, why does this need to extend to an innocent co-defendant? And we say it doesn't. Subject to a postscript point about Beattie, I want to mention the purchase of the farm. If we're wrong in our analysis, but right in thinking that the question is binary, then it wasn't open to the judge to refuse to set aside the judgment against Beattie. And it was wrong of him to extract an undertaking from the other side not to pursue Beattie. If the judgment goes against all parties, it goes against Beattie as well. But be that as may, that's very much by way of postscript, they're my submissions on the principal ground of appeal, unless you have any questions.
May I check if there are any questions? Thank you.
So the second ground is that the judge was wrong in fact and law to hold that Mr. Butcher could not succeed in his defence of late chiefs in circumstances where the claimants had admitted to having delayed issuing proceedings against Mr. Butcher for many years, whilst pursuing parallel proceedings in Scotland in which fraud was alleged against the first defendant, Outlook. We submit the permission should be given and the appeal allowed on this ground. Now the starting point is the law. There's no real dispute between the parties about this. There needs to be shown a substantial and unexplained delay and prejudice or detriment of some sort. We've just included two authorities in the bundle to make good that proposition. The first is Lindsay, Petroleum and Hurd, which you find in tab 2 of the bundle of authorities. We can, on page 7, and we can pick up the judgment of the court at page 25. At the bottom of page 25, the court says this: now the doctrine of laches in courts of equity is not an arbitrary or technical doctrine, where it would be practically unjust to give a remedy, either because the party has by his conduct done that which might be fairly regarded as equivalent to a waiverage, or whereby his conduct and neglect he has, though perhaps not waiving that remedy, yet put the other party in a situation in which it would not be reasonable to place him, if the remedy were afterwards to be asserted. In either of these cases, lapse of time and delay are most material. But in every case, if an argument against relief, which otherwise would be just, is founded upon mere delay, that delay, of course, not amounting to a bar by any statute of limitation, the validity of that defence must be tried upon principles substantially equitable. The circumstances always important in such cases are the length of the delay and the nature of the acts done during the interval, which might affect either party and cause a balance of justice or injustice in taking the one course or the other, so far as it relates to the remedy. And going on to Fisher, which you find in tab 10, starts at page 171. I'm to read from the head note, subparagraph 3 on 172, the judgment. Subparagraph 3 of the head note, that under the equitable doctrine of laches, delay could bar a claim to equitable relief where it would be practically unjust to give a remedy, that the length of the delay and the nature of the acts done during that time were relevant considerations, and some sort of detriment was usually an essential ingredient, that since laches could only bar equitable relief, it could not bar the claimant's claim for a declaration as to the existence of a long-term property right, recognised as such by statute, which was not equitable relief. That further, since any prejudice that the defendants had suffered as a result of the delay was outweighed by the benefit that they obtained, they could not demonstrate that the acts of the claimant during the period of delay had resulted in a balance of justice justifying the refusal of the relief to which the claimant would otherwise be entitled, and accordingly the defence of laches failed. And we can pick up in Lord Newburger's judgment at page 187. Paragraph 61. I don't even need 61, we can go straight on to 64. Bottom of page 187. Fifthly, laches is an equitable doctrine under which delay can bar a claim to equitable relief. In the Court of Appeal, Lord Justice Mummery said there was no requirement of detrimental reliance for the application of acquiescence or laches. Although I would not suggest that it's an immutable requirement, some sort of detrimental reliance is usually an essential ingredient of leaches, in my opinion. And then he cites Lord Selborne from Lindsay Petroleum, which we've already seen. And the question for you, my lords, is whether the judge misapplied this. He summarised my learned junior's submissions about this at paragraphs 125 to 6 of his judgment, which you'll find in the core bundle, tab 5, page 66. And 125 from Mr. Butcher, the following Mr. Banks Jones's main submissions. In his opening skeleton, he referred at the start to what had been very serious allegations of fraud against Mr. Butcher, to the long passage of time since the Manchester proceedings, the events leading to them, to the equitable doctrine of leaches and the claimants having unreasonably delayed in asserting fraud and supposed reliance on the documents in question, which documents are not new and have been in the claimant's possession for many years. He submitted that the delay had caused significant prejudice to Mr. Butcher, most notably the death of most Mr. and Mrs. Franchley, who are now unable to give any evidence in these proceedings about what transpired at the Manchester proceedings. That is, said Mr. Banks-Jones, good reason why a retrial as against Mr. Butcher should not proceed, over and above the fact that Mr. Butcher was not dishonest in the testimony he gave in those proceedings. Now, the judge's conclusion on this issue can be found on page 74. Paragraph 176. In a very short paragraph, he says this: I also reject the defence of leaches. The efforts of the Lindsays, particularly Roger, were sustaining and unrelenting. The process was time-consuming through no fault of theirs. The rule in Honiton and Hewthorne doesn't assist Mr. Butcher, because the findings of fraudulent conduct made by Lady Wolfe are binding on Outlook, and they're directed at Outlook and not Mr. Butcher. They're not relied on by the claimants as against Mr. Butcher, because the claimants don't accuse Mr. Butcher of fraud. But the time it took to obtain those proceedings is a good answer, in my judgment, to the defence of leaches. So essentially, the judge is acknowledging there that there was a substantial delay, but accepted that it was reasonable for the Lindsays to pursue other litigation, making essentially identical allegations of fraud to the allegation raised in this action before starting these proceedings. And we say it's implicit in his findings that he didn't reject the proposition that Mr. Butcher had suffered obvious detriment from the delay. Instead, his rationale was that it was reasonable for the Lindsays to pursue the Scottish proceedings before turning their attention to Mr. Butcher. And we submit that he was wrong to reach this conclusion. Essentially, this is because it's perfectly clear that the claimants knew of the fraud long before they issued proceedings against Outlook in Scotland. And when they did issue proceedings in Scotland, they made the identical allegations they're making in this action. The starting point is Roger Lindsay's own witness statement, and we can pick that up in the supplemental bundle, tab 14. And starting at page 205.
I beg your pardon, could you give me the
Of course,
reference again?
it's supplemental bundle, tab 14, starting on page 205. I'll draw your attention to paragraph 53, just to set the time frame. During 2014, Outlook made an allegation to the police that we'd stolen his cattle. Willie and I were hauled down to Carlisle police station and cautioned and interrogated by Detective Constable Steve Whitehead. I cannot recall the detail of the question.
Sorry,
I'm sorry,
still
my
not
lord.
in the right place. I'm sure it's my fault.
Have you got the supplemental bundle
I
open?
have, yes.
Have you got tab
I'm in
14?
tab 14, yes.
And on page 205,
Yes.
you ought to have Mr. Roger Lindsay's witness statement.
I think that's where I am, yes.
Do you have paragraph 53 starting during 2014?
Yes, sorry, I was looking at the wrong paragraph. My fault. Thank you.
Thank you. So, for the purpose of me taking to paragraph 53 is just to set the time frame. We're looking at 2014 when they were hauled down to Carlisle Police Station. Paragraph 54 over the page, we were called back a few months later, by which time we'd begun to uncover some of the issues with the documents. So I took the evidence of the altered documents and the contradictions we had and asked him to investigate the evidence. He was quiet, did nothing. And then at paragraph 75 on page 210, he refers at, sorry, 74 just to set the scene. In relation to agreements, I refer to what Lady Wolfe says in her judgment. When pressed on the detail of some of the early agreements, Roger Lindsay explained there were some agreements they didn't recognise and they had no record of them. He referred to disclosure by Derek Fradgley in one of the earlier litigations. Derek Fradgley had produced copies. When further copies were lodged, they had been altered from those earlier copies. The Lindsays tried to get the originals in respect to Agreement 1499. They simply didn't recognise this. We established as best we could what the copy documents appeared to show, and this included the documents Mr. Fradgley had brought to us, which he'd placed among the Metal Bridge Limited invoices and delivery notes, which had been stored in the shed, as well as the disclosures and the Manchester action. We'd looked at the spreadsheet that Fradgley had attached to his witness statement in Manchester, and looked at the defence in his witness statement in Manchester, where he stated how those agreements and the sums attached to them had been rolled up and secured against the two farms. This was the same document Henderson Lovey used to forensically examine Outlook's internal records. As regards the box or boxes, I pulled out such copies of agreements as there were, and some other documents. One such document was the board minute, which Lady Wolfe found had a forgery of my father's signature. And at paragraphs 133 to 5, you get when he first had these documents. That's on page 221 of the bundle. Paragraph 133, I refer to what I said in my Scottish affidavit. She has explained that when myself and Co were made bankrupt, Mr. Fradgley came and took away all the original agreements and didn't keep copies. We've never had sight of the originals since. He then says it's for that reason and for the purposes of action, the Lindsays have had to piece things together retrospectively from a box of papers Derek Fradgley delivered to them after MBL was dissolved and from disclosure obtained in some of the court cases. I should explain about the box of papers. This is just one small piece of the jigsaw puzzle that led up to Lady Wolfe's judgment. DF brought the box up one day after he dissolved MBL, so it's before 21st of November 2012 when they ejected us from the farm. So he gets a box of documents in 2012. This is long before Judge Bird gives his judgment, and he comes back to the box again at paragraph 137. Where he says at 137, when the litigation started in 2013, I looked through to see if there was anything relevant, and he goes on to say at 139, as I've explained, after we were asked in 2015 by our counsel to go back over everything that we had, I had a further look through the boxes in the house and extracted such copy agreements and board minutes and were just put together with everything else and added to what we had. Some of the materials there were used in Scotland, including, as I've said, what came to be found by Lady Wolfe as a forged board minute. By this time, the claimants knew that Mr. Fradgley had lied about the bank making demands for payment. That we get.
Sorry, where are you reading from there?
So, I'm sorry.
What are you reading from just there?
I'm just making a statement.
Oh, sorry.
I'm sorry. I was going to take you to the paragraph. It's paragraph 141, where they say this. We knew because of his evidence in Miss Manchester that Mr. Fradgley had lied about the bank. We also referred in our witness statements there that there was a version of an agreement for cattle which suggested they were for 10 years when a cow only produces milk for 3 to 4 years, but there were different versions and all the copies, and the 10-year leases had primary periods in the same documents for 4 years. So we assumed it's an error and would have been sorted out. And as I've explained, Manchester was not about the level of debt, etc., etc. But the important thing is that the lie about the bank, Mr. Franchley had admitted before judgment in the first action, played a central part in Lady Wolf's reasoning as to whether or not there was fraud. And we can see that from Lady Wolf's judgment. And for that, we need to go back to the core bundle, to tab 7, Appendix C, I think, and we can pick it up on page 8184. So the paragraph 7 starts at the bottom of 184. We can to go over the page, please, to 185. And it's about 4 lines in on 185. Then the judge says this: he was importuned to do so after Derek Franchley represented that Euan Lindsay owed a sum of 2.6 million Outlook under certain prior agreements, and that Derek Franchley presented Euan Lindsay with, in effect, an ultimatum that the only way to prevent the bank, whom Derek Franchley represented as standing behind and pressuring Outlook from selling the cattle equipment, was to allure Euan Lindsay to grant the impugned deeds. And we then go on to page 187, to paragraphs 15 and 16, Franchley witness statement. This is not the first litigation between the parties. There have been litigations in England. One at the instance of Outlook resulted inter alia in the realisation of the legal charge over metal farm. In other actions at the instance of Lindsay, the pursuer relies on the Franchley witness statement from one of the English proceedings. Mention was also made in the evidence to other proceedings in the Sheriff's Court. I note the relevant paragraphs from the Franchley witness statement below, that the pursuer founds on the passage in which Derek Franchley admits his representation was a bank behind him, or to which Outlook was liable in respect of sums advanced by Outlook to its clients, were untrue. Derek Franchley's justification for this was said to be that having funders to blame for difficult decisions made the relation between Outlook and its customers easier. She then picks it up on page 266. Paragraphs 147 to 8. As noted at the outset, before his death, Derek Franchley had admitted that his references to funders or the bank were untrue. I think I may not have drawn your attention to the date of that witness statement. It was 2014, and it is important that you have that date. The documentation provided in this proof is replete with those misrepresentations. So, for example, in a fax to Roger Lindsay dated 17th of April 2009, Derek Franchley stated, "I've just had a very unsatisfactory meeting with the bank." In a further communication dated 5th of May 2009 to Roger Lindsay and Euan Lindsay, Derek Franchley was chasing up details of the cattle. He wrote, "We need to nail down these final queries. Perhaps it would help you to know why they've been raised by the bank. Outlook, when it purchases stock or enters into a new agreement, has to borrow money. The bank lends us the money but have ownership of the assets. So when they see several animals are not accounted for, they say to me, pay us back what you borrowed. Therefore, unless I can tell the bank what has happened to the missing animals, they'll expect to repay me the loans." This misrepresentation that was a bank was also used to exert control, even to bizarre extremes, e.g. needing to hold the cattle passports or precluding time to get legal advice about the documents. And then the conclusion about all of this we can find on page 325, at paragraph 247. starts off by saying circumvention doesn't require fraud or even deceit. I accept Mr. Thompson's submission made under reference to these observations that in the present case there was deceit, solicitation and pressure effected by fragility, and that the deceit took many forms. It included obtaining the personal indemnities, falsely representing the level of debt owed to Outlook, and falsely claiming that the bank was compelling him to take action. I also accept as amply supported by the evidence his submission that the pressure of Derek fragilely applied could not have been much greater. Derek fragilely told Euan Lindsay he would be held personally liable for the debts if he didn't sign. So the lie about the bank that Mr. Fragility had admitted long ago as 2014 played a central part in Lady Wolf's judgment, and the claimants had obviously known about this lie for years. And it wasn't just a question of the lie about the bank, or the question of the forgery of his father's signature on one of the minutes. The claimants would have known from reading the board minutes themselves that they were obviously untrue. See in particular the following extracts from Lady Wolf's judgment. We can pick it up on page 213, bundle. Paragraph 61 onwards. 61, she says this: in his parole evidence, Roger Lindsay augmented the description in his affidavit about how board meetings of MBL were actually run. Roger Lindsay had had experience from sitting on other committees or boards of how there would be an agenda to be followed, with an opportunity for those present to speak. The minutes would reflect the discussions and decisions of the meeting. By contrast, at the meetings for MBL, Derek Fragility essentially presented the Lindsays with his instructions as to what was to be done. No prior minutes were reviewed. There was no interaction, no discussion. He didn't provide any financial information relative to MBL. The reality was that Derek Fragility came and told the Lindsays what was to be done and by whom. They felt like they were just employees of Derek Fragility, who was the big boss. Roger Lindsay also said what the board minutes purported to record bore no relation to what was actually discussed at the meeting. They purported to record matters that in truth were never discussed. Derek Fragility did send board meetings by email. Roger Lindsay didn't read these at the time. Interjecting there, we know he started reading them 2013 and again in 2015. He gave examples of entries which he disputed. While some board minutes stated that budget and profit and loss accounts would be produced, this was not the case. E.g. as in the first minutes dated 11th of July, the minutes of 11th of November 2008, or those of 13th of May. Other minutes purported to record that financial statements are received and explained, e.g. the minutes, etc., etc., or that the directors had seen and accepted the financial statements. None of these statements was true. Derek Fragility never put any such financial information before the Lindsays in respect of MBL. Roger Lindsay didn't prepare budgets. In the minute of 11th of July, in respect of the authorisation of Roger Lindsay to negotiate contracts on behalf of MBL, this didn't happen. Any suggestion that Derek Fragility was detached from the operational side was strenuously disputed. He was the boss telling the Lindsays what to do. In respect of any figures Derek Fragility quoted, Roger Lindsay was sceptical. He gave us an example of memorandum dated 13th of May, recorded that Outlook's current investment in MBL was stated to be 151,000. He couldn't understand this as 200,000 of new cash had been provided at the start in late June 2008, but only 100,000 had been put into the bank. Roger Lindsay could not understand how there could be arrears. And then point 5 further down, any entry suggesting that Euan Lindsay was actively involved in any way was a fiction. Roger Lindsay described the suggestion that Euan Lindsay or Roger could have prepared forecasts as ludicrous. The Lindsays simply had no financial information to do so, no bank accounts, no sales ledgers, nothing. And then paragraph 63, there were other matters recorded in the MBL documentation that Roger Lindsay discovered later which caused him concern. And her conclusion in respect to the minutes, we can go to paragraph 149 on page 267. which is said 149, and yet other troubling matters disclosed in the Outlook documentation. There was a statement that Euan Lindsay and James Lindsay had attended a general meeting in Stourport for the purpose of an NBL general meeting. I accept James Lindsay's evidence that neither he nor Euan ever attended Outlook's premises, the location of the purported general meeting. I also accept his evidence that his signature was forged. This is very troubling, all the more so that it seems to be done so casually and simply for the sake of a minute of a general meeting. There are references in NBL's board minutes to many matters that on other evidence I've accepted are patently true, that James Lindsay would be in a position to produce budget forecasts, reports or forecasts, that Euan Lindsay was undertaking stock checks, auditing stems, or that Euan Lindsay was preparing budgets and was proposing the formation of yet another companies. On William Lindsay's evidence of Euan's lack of experience in financial matters, which I accept, the statements that Euan prepared accounts, budgets or forecasts is recorded in the minutes and also asserted in the by hand termination notice addressed to Euan and the Outlook letter are false. All these entries were contrived to give an impression that didn't accord with reality and to protect Derek Fradge's interests. I accept that Lindsay's evidence that some Outlook documents produced in his proceedings were not produced to them on the dates they were produced. And over the page, point 4, more significant than the individual true or misleading entries in the minutes, with their cumulative effect amounted to an elaborate contrivance to give the appearance that Lindsay were in control of MBL and Derek Fradge was at arm's length when the reverse was true. So just pausing there, we have lie about the bank which was omitted as long ago as 2014. There was a forgery of the father's signature on the minutes, readily discoverable from reviewing the boxes. We know they had the boxing materials from 2012. We know you had a look at them in 2013 and a more careful look, I think, with the instigation of junior counsel in 2015. Anyone reading those documents would realise that the case they were presenting, well, let's rephrase that, would realise that the minutes contain a tissue of lies, according to the judgment of Lady Law. So Mr. Lindsay must have appreciated that the board minutes were untrue at the latest by 2015 when he went through the documentation again. And indeed, he confirmed in his oral evidence that he had evidence of fraud that he took to the police in 2014 and 15. And we get that from the transcript in the supplemental bundle at page 104. And this, you can pick it up at page 66, line 21 or what, that's the left hand of the manuscript. I want to ask you about all the police investigations and the allegations of perjury and fraud that are raised with the police in, I think, 2014-15. So at paragraph 53, you say, during 2014, Outlook made an allegation to the police that we'd stolen his cattle. Willie and I were hauled down to Carlisle police station and cautioned and interrogated. I think you go on to refer to him as DC Whitehead. You say, I cannot recall the detail of the questions, but the statements and allegations were incredible. We just answered truthfully and stated our position. Then we go over the page where you say we were called back a few months later, by which time we'd begun to uncover some of the issues. So I took the evidence, the altered documents and contradictions we had, and asked them to investigate the evidence. So by that point, you're approaching the police, as I understand it, saying you think Derek Fradge was dishonest or had lied, and that was something you were prepared to take to the police. Well, even in 2014, is that correct? The police came us accusing of stealing cattle, and in 2015, because these months later on, we were in 2015 after Manchester, when Mr. Fradge had raised 3 actions against us. We were defending them. And when we were going through these things that we found, the agreement that had been disclosed twice, that had been altered between the 2 disclosures, and various things, and I took them down to, and there was other things as well, and I generally can't recall everything I took. But that's the point is that Mr. Fradge was accusing us of a very serious transgression, and I took altered documents down that could prove that Mr. Fradge or Outlook had certainly done it, They refused to even entertain it, but they were quite prepared to entertain Mr. French's complaint against us. So my next question is, if you had then put before the police a whole load of documents you'd said were sufficiently serious that the police need to investigate dishonesty, why you did not then bring proceedings, set aside the mandatory proceedings? Wait a minute, then and there, if you knew all about it, we had evidence is all we had. We raised the action just a few months. It was only months in terms of from that in 2015. We raised the action specifically in 2016. Mr. Weaver's still dealing with the actions that Mr. Frashley brought against us. And there were several things came out from that. I took a very detailed letter to TLT's Outlook solicitors on 6th of February, laid out the issues. They replied and said they didn't accept them. They were carrying on the litigation that was in place at the time. And then he goes on to say, we then accumulated all the evidence and raised the action for Harperfield in December 2016. And he doesn't accept that there was any delay. So, took evidence of dishonesty to the police in 2015. That evidence included evidence of altered documents, and for that we need to go back briefly to supplement to his witness statement and the supplementary bundle. We can pick it up at 209. In paragraph 71, he refers to the fact we had evidence that Outlook's termination letter could not be true. With respect to backed up our pleaded case, we had the agreement in the possession action. That it was an agreement like the collateral agreement we'd raised, and it was our view that Outlook had lodged fabricated documents and lied to the judge, and the termination of the sale and leaseback, and that his own conduct in the Scottish action proved this. And 73, by now we had a number of different versions of the agreements. It was impossible to make head or tail of them. We thought it was essential to get hold of the originals. On 20th of October 2015, Willie wrote to DF demanding he produce the original documents. We no longer have a copy of that letter, and I've already taken you to paragraph 74. There's a reference in your judgment to copies of agreements they didn't recognise. So they had clear evidence of fraud long before they obtained the expert accountant's report on the 19th of February, which demonstrated that Mr. Fradley had also lied about the monies outstanding. For the date of the report, you just need for your note the chronological bundle at tab 3, page 36. (19th of February it was obtained. And for the contents,
Which bundle was that, sorry?
so I'm sorry, it's core bundle, tab 3, page 36. The penultimate entry on that page. And for the contents of that report, we need to go to the core bundle, tab 7, page 277. To paragraph 163. You just really need to look at the heading there. No expert could support the figures in the settlement calculation.
Sorry, could you give me that reference again?
Of course, it's core bundle, page 277. It's the introduction to paragraph 163. And then we can go on to page 325 of that bundle. Paragraph 247, which we've already looked at in the context of the bank. And you can see that Lady Wolf, after the quote, 3 lines after that the deceit included falsely claiming or falsely representing the level of debt. But the point I want to make is this. For confirmation that they had evidence of fraud long before they obtained the accountant's report, one only needs to look at the date of issues of the Scottish proceedings claiming facility, circumvention and lesion. The first claim in respect to the first loan claiming that was issued in 2016. and the second in 2017. And those dates can be obtained from the chronology that I've just shown you at Call Bundle, tab 3, page 36. Now, the point we make in our skeleton argument is that circumvention has its origins in common law fraud. And necessarily, it involves someone dishonestly taking advantage of a vulnerable claimant. And in paragraph 42 of our skeleton, I don't even need to look it up, just for your note, we draw attention to the judgment of Lord Guest in McIntyre and Campbell, where he states that circumvention signifieth the act of fraud. For your note, you can find the authorities bundle, tab 8, page 93, and for our skeleton, paragraph 42, can be found in the core bundle, tab 13, page 543. Now, for completeness, and I think you will probably pick this up anyway in passing, Lady Wolfe held it wasn't necessary to show deceit in a claim for circumvention. But that said, she was satisfied that there was deceit here. I've already taken you to paragraph 247, core bundle, tab 7, page 325, and she went on to find that the alternative case of fraudulent misrepresentation was made out in the facts. This action has raised no new allegations of dishonesty. One can test that by looking at the judge's findings in paragraph 83, which is the core bundle, tab 5, page 57.
Sorry, which paragraph?
It's paragraph 83, my lord.
Thank
you. Core bundle, page 57. And the judge on the fourth line says here, I record that having formed my own independent view, I agree with Lady Wolfe's conclusion, and specifically with her findings to the following effect. And I make the same findings in this action. One, that Mr. Fladshew created fabricated board minutes of MBL in June 2008 on its incorporation, evidencing a meeting in Starport at which the directors, Euan and James, were not present, according to record their presence. Two, that Mr. Fladshew was a de facto director, exercised control over it, and created a trail of documents that were not genuine to create the false impression that the directors, Euan and James, were managing its business. Three, that Mr. Fladshew deliberately made the Lindsay think MBL's financial position was worse than it was in the period from its incorporation up to 23rd August 2009. Four, that he dishonestly told Roger at a meeting on 23rd of August 2009 that MBL was insolvent and that a fictitious bank could take proceedings at any time to place it in an insolvency process. Five, that he dishonestly told Euan at the meeting on 26th August, at which Roger was not present, that unless new agreements were signed at once, Euan could be sued by the fictitious bank for over $2 million. Six, that he produced a settlement calculation at that meeting, falsely representing to Euan that the balance of capital rent due was a little over 2.6 million. Euan could settle for discounting 1.8 million. Seven, that Euan was in poor health. Eight, that each of the four instruments were obtained by undue influence. Nine, that none of the family members were aware of their prior personal indemnities. And 10, that Mr. Fradgley systematically underrecorded the amount of interest payments due. So it follows, my lords, that the claim against Mr. Butcher could and should have been brought against him years ago. The judge's finding that the claimants were acting reasonably and not taking steps to set aside a judgment alleged to have been procured by fraud until April 2023, when they were making these allegations of fraud and perjury to the police in 2014 and 15, and had issued proceedings in Scotland in 2016 and 17 making the same allegations, it's just impossible to justify. If the claimants were willing and able to make these allegations to the police as long ago as 2014 and to repeat them in Scottish proceedings, there was no reason for them to wait almost a decade before making him in the proceedings the subject of this appeal. We say that the prejudice to Mr. Butcher is obvious and public. Because Judge Bird gave judgment on the 2nd of June 2014 these proceedings were not served on Mr. Butcher until about April 2023. And I take to a comment from the judge during argument at the supplementary bundle tab, page 95, please. It's page 37, line 4. So the judge notes in passing, presumably until served with those proceedings in 2023, he was just getting on with his life. And one imagines he didn't know anything about the Scottish proceedings, apparently. Now, my learned friend wasn't willing to concede that proposition, but there's absolutely no evidence at all to suggest that Mr. Butcher was made aware of the Scottish proceedings at any time before these proceedings were issued against him. It follows that Mr. Butcher had been left in limbo for more than a decade and is now facing the prospect of a further retrial, or a retrial of the Manchester action, with little or no documentary evidence in his possession with which to defend himself. The main protagonist in that litigation having since either died or gone into liquidation.
Mr. Wardle, can I ask you this? Presumably before the proceedings in 2023 were issued against Mr. Butcher, there's been a letter before claim, had there?
Not, I imagine there was, I haven't seen it.
Right. But on your submission, was any notice given to Mr. Butcher after 2014 and at least not shortly before the 2023 proceedings?
No notice at all.
So he
Other than possibly a letter before claim.
right, yep, that's
Which
fine.
we can check over the short term.
And as you tell us in your skeleton, he was not a party to the Scottish proceedings.
No.
But it's your case, is it, that he was not in any way made aware of the existence of the Scottish proceedings?
Exactly.
Right.
So my lord, we say it follows that the prejudice to Mr. Butcher is obvious and palpable. If he'd been made aware of the allegations and of the facts of the Scottish proceedings, he would have had the opportunity of investigating the accuracy of the allegations with Mr. Franchley, who didn't die until July 2017, after the issue of both sets of the Scottish proceedings. And I get the date of death, call bundle, page 43, at paragraph 4, last sentence. He died in July 2017. Now,
sorry, I don't quite understand that. I mean, I'm not disputing the date of death of Mr. Franchley. But what is it you're postulating that Mr. Butcher could have done?
if he'd been made aware of the allegations, he could have then investigated with Mr. Franchley the extent to which the core complaint that these documents misrecord what was discussed, misrepresent what was owed, and a fabrication. So he could have investigated. By the time it comes,
but I'm trying to understand what you're submitting Mr. Franchley would have said if asked. So there are two possibilities at the moment, it seems to me. Either Mr. Franchley would have admitted that he'd acted dishonestly in the ways subsequently found,
yes, that's one
which seems unlikely,
agreed,
or he would have denied it.
exactly, and given an explanation in support of that denial. And it's that explanation in support of the denial.
But what explanation in support of the denial are you postulating could have been given?
Well, to take, I mean, this is pure speculation. The prejudice is in the inability to investigate. But for example, it may be Mr. Franchley would have had proof of attendance at the Starport meeting. It may be Mr. Franchley would have had access to the relevant, to the accounts, projection, and so on and so forth, that the minutes said were discussed at the meeting, and the Lindsays denied vehemently weren't.
Well, let's take the settlement amount, for example, because two forensic accountants were instructed to look at the figures, and neither of them could justify the settlement demand. So, are you really asking this court to suppose that Mr. Fradgley could have justified it when neither of the accountants could?
The prejudice is a loss of opportunity. I'm not asking this court to conclude that the findings against Mr. Fradgley were incorrect. I've got no basis for saying that. But a professional man who's left in limbo since 2014, not told of any allegation in 2023, if he'd been told at the relevant time of the complaints and of the allegations, he would have had the opportunity to investigate. And that's the prejudice. And it doesn't cease to be prejudice, if I may say so, because it may be he wouldn't have got a satisfactory answer.
Suppose he got no answer from Mr. Fradgley. I mean,
Still
because I mean, Mr. Fradgley was going to die come what may. Yes. So suppose he'd simply got no answer from Mr. Fradgley. So neither, and this may actually be the most likely theory of all, Mr. Fradgley wouldn't have made any admission, but equally he wouldn't have made any denial. He would have simply not answered, and then he dies.
Forgive me, I would submit you don't test prejudice by speculating as to what might have happened. The prejudice is the lack of opportunity to investigate. That's where the prejudice lies. Anyone accused of fraud will want the opportunity to find out where the truth lies. It may be the truth lies against them, but they're still prejudiced by the fact they haven't had the chance to find out.
But you're putting the lack of prejudice, I apologise, as I understand it, squarely on being deprived of the opportunity to get information from Mr. Fradgley.
Yes, and to examine the documents, the relevant documents, in conjunction with him.
Right, okay. And can I ask a slightly different question on that basis? Given that Mr. Fradgley dies in July 2017, why is delay by the claimants after that point in time material? Because the opportunity then has gone forever.
Well, the delay after that doesn't increase the prejudice, but it's still delay. A lengthy delay of itself can be prejudicial to a professional man. Why should he be subject to these proceedings many years after the event, when the claimants had the relevant information at their fingertips before they issued the Scottish proceedings? That's the way we would invite you to look at the question. And we're able to point to a specific prejudice, being the loss of opportunity of being able to investigate. That's the case.
Is there any authority for the proposition that it's prejudice to lose an opportunity to investigate, even if that investigation wouldn't have come up with anything?
Not so far as I'm aware, but where I'm balking and quarrelling a bit, I don't think you should be looking at what the outcome of the investigation would have been. It doesn't cease to be prejudicial just because he may not have got joy or as much joy as he would have wanted. He hasn't had the opportunity.
But that's what I'm asking. There's no authority on that.
Not as far as I'm aware, no.
I think you would say that if one unpacks what is going on, whenever somebody litigates something many years after the event, there are various things that are potentially going on. One is that someone may not have the opportunity to gather the evidence so as to have a fair hearing.
Yes.
But you would submit that it's not confined to that. There are other things that are potentially going on. Another thing is that people are entitled to suppose that life has moved on.
Exactly.
And another, which is distinct but not unrelated, is that in some circumstances the law gives you a defence to an action, even if the action would otherwise have merit.
Yes.
Simply because of the passage of time.
Yes.
Now that in the common law, that happens through rigid time limits, which are potentially extendable, but nevertheless, usually there are fixed time limits laid down in legislation.
Yes.
In equity, it's not so clear cut. because you're invoking the doctrine of leeches.
Exactly.
But you say, I think, that the underlying policy concerns of the law are, if not identical, similar.
Yes. Absolutely so. That's how we see it. And how we put it.
You may be coming back to this. I don't know when you're going to address it, but when I was considering the application for permission to appeal, one thing I had in mind in adjourning it for this court to consider as a whole, rather than simply to grant or refuse permission on the papers as a single judge, was that the response on the other side was that this is not how the case had been pleaded on behalf of Mr. Butcher, and that it would require A, an amendment to pleadings, and B, some evidence. Are you going to address
I was going to touch on them, but leave most of any answer to his complaints to that effect to my reply.
I see.
So, just touching on them. First of all, they complained that Mr. Butcher's witness statement didn't deal with the question of prejudice.
Well, could we start with the pleading point, please?
Of course. Their complaint about that is that they say that our skeleton argument effectively makes a slightly different point to our pleaded case. I accept that. I rely on our pleaded case. In terms of our pleading,
Well, where do we find that?
the pleading starting point is 400 tab 8 462. I think that'll be your second volume of the law. Page 462.
Yes.
And it's paragraph 7.5.
Yep.
It's averred that under the doctrine of leeches, the claimants are now out of time. Claimants having unreasonably delayed in asserting fraud and supposed reliance on the documents in question, which documents are not new, but at all times been in the claimant's possession, and the length of time which the claimants have delayed in commencing these proceedings, having caused significant prejudice to the second defendant, and seeking to meet the allegations made against him, most notably the death of Mr. Fradgley, is now unable to give any evidence in these proceedings. The point is picked up again on page 470, at paragraph 25.4. That under the doctrine of leeches, the claimants are now at a time in which to bring any such claim. The claimants having unreasonably delayed in asserting fraud and supposed reliance on the documents in question, which documents are not new and have at all times been in the claimant's possession, and which delay has caused Mr. Butcher significant prejudice in seeking to defend the allegations made against him due to the passage of time, most notably the death of Mr. Fradgley.
So, where does that say anything about the inability to investigate?
We go on, if you bear with me for a second, please, we go on to supplementary bundle tab 6, page 91. As part of granting permission, the judge wanted further particulars of the leeches and detriment. And what's said in the second paragraph here is the unjustified delay in bringing this new claim, coupled with acts amounting to waiver and not previously having adopted, have materially impacted Mr. Butcher's defence of these proceedings. The documents referenced throughout these paragraphs now adopted by the claimants relate to documents produced exclusively by Outlook and involved claims in which Mr. Butcher had no involvement. Had the claimants pleaded the case against Mr. Butcher from the outset when those documents came into their possession after MBL was dissolved and while Mr. Fradgley was still alive, as confirmed within the witness statement of Roger Lindsay, Mr. Butcher had been afforded the opportunity of canvassing the creation of those documents with Mr. Fradgley, which documents he had no role in creating, and responding according to the allegations now made against him in the amended particulars of claim in state of reliance on those documents. The unexplained and unjustified delays therefore caused Mr. Butcher significant prejudice in defending these proceedings, the author of those documents having since died in the interim, thereby precluding Mr. Butcher from mounting a full defence to the very serious allegations now made against him by reason of those documents.
Well, that's helpful, thank you. But I'm still a little puzzled and I want to go back over the question I asked earlier because I'm not sure I fully understood your answer to it. So, is it your submission that there was delay amounting to laches on the part of the claimants as at July 2017?
I don't put it quite like that. I hope you don't think I'm refusing to answer the question. My starting point is delay per se can give rise to prejudice. The longer the delay, the greater the prejudice to be inferred. In this particular case, there is an additional factor, that the inability to raise the allegations at the time of bringing the Scottish proceedings meant that Mr. Butcher could not investigate. Now, we haven't put our case on the basis of abusive process, but if you draw a sort of rough analogy from Lindsay, they had all the relevant material as at 2016 and 17, which they could deploy against Mr. Butcher. Why didn't they do it? Why should they be allowed to do it now? That's really how I put it. You can't we would say you can't just sort of look at one particular element of prejudice and say that's the answer to late cheese. It's the entirety of the delay coupled with particular aspects of being unable
The
to...
focus of this document, like your earlier submission, is all about the inability to investigate with Mr. Franchley. And I'm struggling with that at the moment because, and I take your point, I have heard what you've submitted about the more general prejudice due to delay, but focusing specifically on Mr. Franchley, at the moment it seems to me to be a bit difficult to say that there's undue delay by the claimants as at July 2017. And after July 2017, the delay is not operative because Mr. Franchley has already died and therefore the opportunity to investigate has permanently gone. That's what I'm struggling with.
No, well, I see the point. It would be difficult to argue that there was undue delay before 2017 so as to justify a plea of laches at that time. But I would invite you to look at all of this in the round.
Is another way of putting the point that they were able to bring the Scottish proceedings in 2016, so why couldn't they have had similar proceedings in England?
Exactly.
And if the reason is, as the judge, I think, found, that they were concentrating on the Scottish proceedings, your answer would be, well, that's fine, but your client should not be the one who has to bear the prejudice as a consequence.
Exactly.
If they don't have the resources or the time or the inclination to fight two cases at the same time, you submit that's their problem, not his.
Exactly that. And it is a rough analogy, but going back to Finzi, the Privy Council has now said that if you have the relevant material before Action 1, you can't deploy it subsequently because to do so would be abusive. Well, it's an obvious analogy here. They had the relevant material they could have deployed against Mr. Butcher in 2016, but they chose not to. Why should they be allowed to do it now? And yes, we're not putting the appeal on the basis of abuse, but it feeds the leeches argument. Why should he be exposed to have a judgment against him, in his favour rather, 2014, set aside in 2025, and face a prospect of a trial? Anyway,
Just 2 points of detail on that. First of all, the Scottish proceedings were commenced by Outlook, weren't they? So
no, there's sorry, I better show you the chronology about that. CB Core Bundle tab 3, page 36. Scottish proceedings, 2016, 2017. There was the claimants' actions in Scotland. There were other proceedings by Outlook in Scotland, but these are the claimants' actions which were consolidated, which eventually were the subject of Lady Wolfe's judgment.
So who kicked things off in Scotland?
There was an earlier kicking off by Outlook, but this prompted the two declaratory actions in which they sought relief for circumvention, facilitation, lesion. I've got the wrong order, but that was the basis of their relief, which is effectively seeking relief for fraud. I'm grateful, my then friend. Can we go to 182, the core bundle?
182.
Yeah. Paragraph. Ah, thank you. Thank you. This is Lady Wolf's judgment. So the pursuer in each of these two commercial actions is Mr. Lindsay, who sues in his capacity as executor for the estate of his uncle.
Yes. I think you had another question.
So, sorry.
So, no, my other point was just this. You refer to abuse of process, but the abuse of process you're considering then is not bringing this action at the same time as the Scottish action.
Yes.
Whereas the abuse of process being considered in Lindsay is not bringing it before the first action against Mr. Butcher, the English proceedings. It's a different point, isn't it?
That's why I said it was a rough analogy. So I'm not saying it's a precise analogy, but I draw comfort from that approach. And the only other complaint that my own friend raises that I was going to deal with in opening was he says that Mr. Butcher's witness statement didn't deal with the question of prejudice. We say there's nothing in that. It's plain that his ability to defend himself, because of the passage of time and the death of Mr. Fabricating, has been severely compromised. And he doesn't need to state the obvious. And in any event, he has.
Is there any particular passage in his witness statement that you would rely on, or are you simply saying it's obvious and he didn't need to say anything at all?
It's obvious he didn't need to say it, and in any event, the defence would have had a statement of truth.
You say would have, I mean, presumably did have.
Well, I sincerely hope it did have. I confess I haven't double checked. But thank you. My lord, unless I can help you, that is the appeal on the second ground.
May I check if there are any questions? No, that's very helpful. Mr. Bacon, it seems to me that we're doing well for time overall.
Yeah.
So unless you want to use a few minutes now,
No, I
should
don't
we
need
begin
to.
to
I
hear
have
you?
one observation to make, if I
Of
may.
course.
My only friend has suggested that he would come back on the point that I made, which Your Lordship raised when giving permission to appeal, that I'd said that there was an unpleaded and new detriment. And he said he would come back on that on reply. I'm not particularly comfortable with that, I must say. Can I just ask you to look at page 545 of the main bundle?
Yes.
This is part of my learned friend's skeleton argument on seeking permission to appeal. And if I could ask you to look at the paragraph 48 once you've found that page. He says, having concluded the match proceedings and in reliance on a clear judgment in his favour, he proceeded on the basis that no further claim would be made. He did not therefore take steps to retain documents relating to his receivership or retain other crucial paperwork which would have been of assistance to him in defending these proceedings. But that's different to the prejudice that's pleaded and now sought to relied on.
Apologies for interrupting. I thought I'd made it clear that I was just relying on my pleaded case. That I accept there's a disparity between that paragraph in the skeleton of the pleadings. I thought I made it clear in answer to a question from the bench that I wasn't relying on that paragraph in the skeleton argument.
Ah, right.
The permission to appeal is sought on the basis of that prejudice. I thought, I understood an editor said that he would respond to any complaint I made about that in his reply.
Well, you're right to that extent, but it has now been made clear by Mr. Wardle that he does not rely on paragraph 48 of the skeleton argument, which I think should give you some comfort in knowing what you need to deal with.
I mean, of course, I'll say that it neither does it actually say. I actually now rely on the original detriment. The appeal, the application for permission that I've been dealing with is based on this skeleton argument, not on something which says, in fact, I'm not going to rely on that. I'm going to rely on what I originally said. That's not part of actually where he seeks permission to appeal. It seems to me he's completely changed the basis of that application. But if it's being said he's not going to respond to that at all and he's not going to in any way refer to paragraph 48, then I think I've made my concern was that I wouldn't know what case, I still don't know which case I've got to meet.
Well,
in
he
relation
said
to
he's relying on the pleading case.
Yes.
So that's become clear now, I think now.
Very good. Well, we look forward to hearing you at 2 o'clock. Can I just check with you both overall? I don't want anyone to feel under pressure. You were given, I think, a time estimate of a day and a half, by me at least. Are we going to go into tomorrow?
I'd be a little surprised. It depends how much intervention we have. We discussed this before. I think
We might well finish today.
All right. Well, if we do, that's fine. But I don't want anyone to feel they haven't had a fair hearing. So if it does stray into tomorrow, then that's what will happen.
I won't rush, but I think I think we may well.
2 o'clock then.